और अब कहते हैं ना, अगर संकल्प पुण्य की वेदी पर एक विचार होता है तो वो संकल्प बन जाता है। ये हाथ अगर यूं जुड़ते हैं तो प्रणाम बन जाते हैं, और ये हाथ अगर यूं जुड़ते हैं तो ताकत बन जाते हैं। जी हाँ, एमएलए जी के सहयोग के बिना आज की इस समिट का सफल आयोजन नहीं हो पाता। मैं बड़े ही श्रद्धा प्रेम से आमंत्रित कर रही हूं डॉक्टर नीरज नागपाल, जोरदार तालियां बजाइए, सीनियर गैस्ट्रोएंट्रोलॉजिस्ट जो पास्ट प्रेसिडेंट आईएमए के हैं और जो आज के समय में लीगल कन्वीनर हैं मेडिको लीगल एक्शन ग्रुप के, जो कि एक नॉन प्रॉफिटेबल संस्था है जो हमेशा 2012 से हमेशा चिकित्सक हितार्थ के लिए खड़ी रही है। जोरदार उद्बोधन, शानदार उद्बोधन अभी आप सुनेंगे। तालियों की गड़गड़ाहट के साथ स्वागत है सर।
Thank you so much, ma'am. Before you start my timer, please give me 2 minutes. Dr. Yogendra Malik is here, and I don't want to lose this opportunity. It was a keynote address, and if I had asked some questions, Ashwini would have sacrificed me because it is tradition you don't ask questions in a keynote address. So my request to you, sir, under RTI, Medical Legal Action Group has asked different state councils, if a person from Mumbai wishes to practice in Punjab, what is the procedure? Will you allow him or will you ask for an NOC? You said it is going to be as simple as a click of a button. 2 state councils have already given me under RTI the information that they want an NOC, number one, and I'm not asking a response, sir. I'm just giving you the problems which are, so that when you come up with the regulations while you are doing your job, you are aware of that. Second thing is, we have a huge list of duties and responsibilities of RMPs. Could we please have, out of those 104 pages, 1 page of rights of doctors? The only right of doctor we have had in the regulations which were withdrawn was right to charge money. I mean, that too, under Clinical Establishment Act, we do not have any right to charge in an emergency. So that right alone, I mean, I have a right to safe environment. At least that much you can write ki I have a right to a safe working environment. So please have.
Sir, though I thought I'll not respond, but I think I should. 3 things were there in which the regulation, unfortunately, which the fraternity opposed. I'll become emotional, sir, which I should not. So I'll not go into the details of how we behave. There were 3 things, sir. One, right to charge money was there. For the first time, we introduced. Second, violent behavior. If a patient or the family behaves violently with you, then first time, you cannot abandon the patient, but you can tell him that you go somewhere else. It was not there. It was unethical earlier. And the third thing, sir, which you said regarding?
Abhi aa rahe hain aur, sir. Abhi,
yeah.
List
so I think I'll not be able to answer all the questions because then the whole day will be like this. But I'll definitely sit with Nagpal sir and assure you. The only thing I assure is we are open to any suggestion, criticism, and we are open to change also. No, sir, we can't have.
Sir, वो regulations doctors की हैं, RMPs की हैं. Another very small point, sir, please, when you take these workshops for people who sit in medical councils and give judgments, please ensure that the use of term gross in their judgments can have disastrous consequences for the doctors. Because this term gross is not understood by doctors when they are using it, but it has huge implication for the legal community and for the police actions. Another problem which has occurred now, which you raised, and I must address that, we are still India versus Bharat. We have 80%, 90% of our patients who still are dependent totally on us. You are saying regarding patient participation that in the health education scenario we have in our country, we are extrapolating something from US and bringing it to India. Maybe 30 years down the line this will work. But today, some leeway will have to be given before we go for patient advocacy total and patient participation total. I'm sorry to have brought these things up, but I thought it is an opportunity I don't want to miss. Thank you.
Thank you, sir. After a wonderful discussion on medical ethics, now we are moving ahead. The next session will be on Let's CPA 2019 Not Turn into a Legal Terrorism. It is a wonderful topic, and for this, I would like to invite on dais Chairperson Dr. Rajveer Arya sir. He is retired professor from SMS Medical College, Jaipur, and he is member of Senate, University of Rajasthan. He is State Secretary of Rajasthan Medical College Teacher Association and also State Secretary of Association of Surgeons of India. Second chairperson would be Dr. Hemant Bhartiya sir. He is Director and Head Department of Neurosurgery, Fortis Hospital, Jaipur. He is past President of Neurosurgical Society of India and past President-elect of Skull-Based Surgery Society of India. Dr. Hemant Bhartiya sir. Third chairperson is Dr. Manoj Singhal. He is MBBS and MD pediatrician. He is practicing since 1992 at Ratna Hospital, Narnaul. And for the topic, we have a wonderful speaker, Dr. Neeraj Nagpal sir. He is consultant physician and GI endoscopist, managing trustee of Medical Legal Action Group. He was secretary and president IMA Chandigarh State Branch, director Hope Gastrointestinal Diagnostic Center, Chandigarh, and he authored multiple books and research papers and various chapters and journals. And he is a very excellent speaker, and he will prove in next 20 minutes. Over to you, sir.
So with the permission of the chair, I think I'll straight away start. The topic, do you have a slide changer? How did doctors come within the purview of CPA? Initially, there were some judgments which said that doctors should not be covered. There were some High Court judgments which said doctors should be covered. And there was confusion going on, and the entire matter finally came to Supreme Court, and in VP Shanta and others, this was finally settled that Consumer Protection Act, doctors will be covered within the definition of, of service as given under Section 2 of CPA 1986. However, if you go through the VP Shanta and the others' judgment, what did it say? It said very, very clearly that only outright cases of negligence. You have to operate on the right side, you're operating on the left. These are the kind of cases because of the summary nature of the consumer judicial process. So only these cases should be taken up, and cases which required evidence of experts, where arguments were to be made and where evidence was to be produced, these cases should go to civil courts as they used to go earlier prior to introduction of Consumer Protection Act. This exception lasted for around 7 years, and then in 2002 we had a judgment of J.J. Merchant where it was said no, even in cases which require, even in complicated cases where evidence of experts is required, case can still be taken and adjudicated under Consumer Protection Act. There were many arguments which were placed before the Supreme Court why doctors should not be covered under CPA, but the Supreme Court had said categorically that it is not possible to hold that medical practitioners must be treated to be excluded from the ambit of the Act, and the service rendered by them is not covered under the Section 2. We had made an argument, when I say we, it is the advocates of IMA and IMA itself, that the people sitting in the bench in consumer courts do not have medical knowledge. But the Supreme Court answered that and said that in consumer courts, cases come from very different walks of life, and it is not possible to have experts from all walks of life in a court on the bench. So it is not possible to accept this argument that since these people do not have that much medical knowledge, hence medical cases should not come into consumer courts. But look what happens. Our courts are very, very wise and they know everything. Can you read the gist of this judgment? Removal of the gallbladder instead of conducting laparoscopic surgery to remove stones of the gallbladder without the consent of the complainant was incorrect and against medical ethics. No case has been made out that the surgery was essential in a life-threatening situation. And this is not from a district consumer dispute redressal commission. This is National Consumer Dispute Redressal Commission. And then we say that medical knowledge is not necessary for people who are to adjudicate cases of alleged medical negligence. Then we said the procedure is summary in nature. We cannot argue, we cannot defend ourselves. To that also they said, but the answer they had given was only outright cases will be taken, so it is all right even if it is summary in nature. But that, as I showed you, was overturned within 7 years. Now let's come to the crux of the matter. How many consumer court cases do you think are happening in the country? In 1995, I published the first compendium of CPA medical judgments, and we had 113 cases starting from 1960s. I think Trimbak Kodbole judgment, Dr. Pradeep Arora will vouch for me. But since then, there were only 113 cases of medical negligence which were adjudicated in courts in India, and including consumer courts. Here, we did a search from 1st January 2023 till 31st December 2023. National Consumer Dispute Redressal Commission alone decided 261 cases in this 1 year. 54 state consumer dispute redressal commissions, including circuit benches, decided 1,048. Mind you, some state consumer dispute redressal commissions and their circuit benches still do not upload their judgments on the Confonet site. So this number is bound to be more. The actual figure is bound to be more. Now we had to find out what happens in the district commission, because now 99.9% of the cases of medical negligence are coming to district courts. Because we are not getting paid more than 50 lakhs for my services. 50 lakh में तो मुझे खरीद लो, मेरी services क्यों खरीदनी है? So most doctors would not charge more than 50 lakhs, and the bar today is you can ask for 200 crores, but if you have paid less than 50 lakhs, your case will go to District Consumer Dispute Redressal Commission. So it is very important to know what is the number of cases in District Consumer Dispute Redressal Commission, and very few District Consumer Dispute Redressal Commissions upload their judgments. So we took one state, we took the state of Haryana. State of Haryana, State Commission decided 10 cases in this year. All district commissions in Haryana, they decided 170 cases. So the ratio of 170 to 10, which was 17 times the number was in district commissions. The same ratio we multiplied with the state commission and got the figure of 178816 as the total number of cases which were filed in, which were decided by district commission. Total number of cases decided by consumer courts, national commission, state commission, and this nearly 20,000. Number of cases pending in courts. Now, this we are talking of only cases which have been decided in 1 year. So the cases, number of cases pending in courts, I have taken approximation only of 2 times. This is very, very efficient courts if their pendency is only 2 times the number of cases they are deciding. To my mind, this would be at least 5 times, but let us be conservative and say 2 times. So that means around 38,000 cases are pending in courts in that year, which means the total number of cases decided and pending in consumer courts for that year would be 57,365. Now, if you add every case which goes to court or to be decided or filed with the police, there are at least 2 cases where the hospital or the doctor has settled with the patient. कुछ दे ले करके हमने जी वो मामला खत्म किया. This figure again comes to 57,000. And do you know that 80% of all disputes arise against hospitals, small and medium healthcare establishments, or corporate hospitals or government hospitals? Single clinics or Ayurvedic clinics or homeopathic clinics, the numbers are very, very small. Majority are interventional procedures for which these cases have been filed. So if 80% of this figure is taken, it comes to nearly 45,000. And do you know the total number of hospitals in India, government and private included? The figure is 69,264. So with 45,000 cases decided or pending in courts, you have nearly 0.662 case against each hospital every year. So this is something which we need to be very, very careful about. And if we have included the out-of-court settlements, this is the kind of figure we get. So point is, what I'm trying to show is the number of cases which are being filed in consumer courts is exponentially increasing year on year. One simple line for which I needed to show you all that data. Also, the quantum of compensation which is being awarded by courts these days is again multiplying exponentially. There is a new formula. Earlier, the calculation used to be what the old calculation was, and it was limited. I'm forgetting the term which was used for that. No. This is restitution integrum, multiplier method. Earlier, it used to be multiplier method, which was used for calculating the compensation. Now they say it is restitution in integrum. And this is the way you calculate. So effectively, if a 35-year-old man is earning 2 lakhs, the figure will go anywhere to 7.28 crores and more if we simply calculate at this level. Is it a scaremongering which I'm doing? We already have Jacob Matthews, we already have Kunal Saha's judgment, which said very clearly that 11.6 crores was awarded. Then we also have V. Krishna Kumar. This is a government hospital. Free treatment, where 2.28 crores was awarded. And mind you, besides this award, you can also be awarded under Article 32, under Article 226, under law of tort, and even while being criminally prosecuted under Section 357 CRPC. There are many learned people in the audience. Maybe I will make a legal mistake. I am a student of law. I am not an expert in law. Though sometimes Dr. Suresh Vashisht and Ashwini will try to pull my leg by trying to show that they are touching my feet. But actually it is only an exercise to show me that they can bend and I can't. So, the pecuniary jurisdiction today is 50 lakhs if a patient has paid me, not what he has asked for. It will come to district. From 50 lakhs to 2 crore, it will go to state, and 2 crore and above will go to National Commission. Which procedure in India costs 50 lakh to 2 crore? Maybe liver transplant, and that too maybe if done in Medanta or one of these places. In my place, in these figures, we buy and sell doctors. I mean, these are not the figures for medical treatment. But are the doctors never at fault? We are at fault. Why we are at fault? Because We are all too intelligent to get together. We are too intelligent to work with each other. We are too intelligent to oppose a draconian regulation or a law which is being brought because it does not have my name on it. When we are talking quantum of compensation, some compensations I'm showing you more than 1 crore or significantly high compensations. This was V. Chandrasekhar, he was a TT champion, and in 1993, 17 lakhs was awarded. We considered that to be exorbitant in those days, and maybe if you calculate that amount for today's worth, it was. But keep looking. Even in a Tamil Nadu hospital which conducted free eye checkup camps, 9 crore plus was awarded by a sessions court. So this is not, what I'm saying is not scaremongering. I have been told by many people that when you speak, we want to give a practicing medicine, we are so scared. तुम डराते बहुत हो. Well, अगर डर जाओ बहुत अच्छी बात है, because 25 साल से तो मैं ऊपर 27-28 years I have been speaking my head off. It doesn't seem to have changed anything, except maybe some people have joined hands and we are a movement which is growing. So you can have any number of cases, and even today I get people who are very surprised and tell me, अच्छा डॉक्टर साहब indemnity insurance भी लेनी पड़ती है. हम सिविल हॉस्पिटल में तो कभी नहीं लेते थे. अब 4 साल से मैं प्रैक्टिस कर रहा हूँ एनेस्थीसिया. Why should I be taking? जब वहां नहीं लेते थे. आप तो कहते हो गवर्नमेंट हॉस्पिटल पे भी CPA लगता है. I have no answer. Again, not only are the courts philosophical, even us doctors, we think we know everything. No one is immune, whether it is a government doctor. Mind you, even R&R hospital, military hospital Delhi, has been prosecuted under Consumer Protection Act. So today, if you ask me, is there any hospital in the country which is not covered under Consumer Protection Act, my answer will be probably none. Why? Because even so-called free hospitals are all charging something from some patients, if not all. If they have put in a CT scan, maybe they are not charging 4,000, they may be charging 800 rupees, but some money is being charged. Maybe they are not charging all 100 patients who come to them, maybe they are charging only the private patients. All right, but even the patients who have not been charged are covered under Consumer Protection Act as consumers. Anybody else is making the payment. It is not the patient. The patient's father makes the patient's insurance company makes the patient's organization where he works makes the patient, ESI, it doesn't matter. Everybody is covered under Consumer Protection Act. And there is no limit on what compensation can be asked for. We already have Kunal Saha case where I think first he had asked for 97 CR, 77 CR, which with interest came to 97. And then he increased it when he went to Supreme Court to total 200 CR. And the Supreme Court, in the generosity mood they were in, awarded only 11.6 crores. So I think we should all thank them. And the interest on compensation awarded can be anywhere from 6 to 18%. There is no fixed guideline what interest is going to be awarded and from when. It can be from the date the event occurred. It can be from the date the case was filed. It can be from the date the judgment is delivered. There is no guideline. Any judge, he gets up on the right side of the bed, he can decide 18%. He fights with his wife, he can decide 12%. He does not fight with his wife and he's a happy person, maybe 6%. There is no guideline. There is no fixed way to calculate how much interest is to be awarded and from when. And patient may ask for 3,000 rupees. Court is within its powers to award 5 lakhs. So I have had this question asked to me by many people कि डॉक्टर साहब हमारी 5 लाख की इंश्योरेंस है, बंदे ने 1.5 लाख का केस किया है, दे देंगे. My dear sir, if you don't defend yourself for that 1.5 lakhs, it is within the court's powers to award 20 lakhs. And then you will say, I didn't get a chance to defend myself. The courts are within their powers to give compensation what they deem fit, even more than what the patient has asked for. And look at the difference between 86 and 2019. The punishment for failing to comply with the orders of the commission. We have had a doctor in Chandigarh who was awarded 2 years jail sentence because he didn't pay the compensation which the consumer courts awarded. This has been increased in CPA 2019, e-filing of complaints. Not only can you order on Zomato, you can also file a case against me, probably by the same mobile phone or the laptop you are using. This ease of filing a complaint, and if the court does not accept or reject within 21 days, it is deemed accepted. So the number of cases which can be filed have increased exponentially because of this ease of filing the complaint also. Second appeal, 2019 I'm talking about, can now only be on a substantial question of law. Earlier in CPA 1986, it was when a case had to go to Supreme Court. Then it had to be on a substantial question of law. I hope I'm right when I say this, Hitesh or Dr. Pradeep. But my understanding is, earlier, if you had to go to Supreme Court to fight your case, it had to be on a substantial question of law. It could not be on the facts which have already been taken into consideration by the lower courts. Now, even National Consumer Dispute Redressal Commission, you cannot go unless it is a substantial question of law. And of course, negligence तो नहीं है डॉक्टर साहब, but वो तो poor है patient. आप insured हो, इसको दे देते हैं थोड़ा बहुत. Your generosity is reported as my negligence, Your Honor, which is something I find difficult to live by. Not giving concession to VIPs was the argument given to file this case. This was Justice Verma. He was a Chief Justice, Supreme Court of India, and he was admitted in Vedanta, and 34 eminent people, including very senior advocates. I think Ramjit Phalani was also part of that. They made a complaint where, not to Consumer Court or to the police FIR or to the State Medical Council, to the Prime Minister. The complaint was made to the Prime Minister. And what is the ground of the complaint? That this hospital could provide a 24-hour ambulance for a dharna which was occurring in what Maidan? No, sir, I don't want to give Ashwini more ammunition, so I will finish it. And this case went to Supreme Court, and 10 crore compensation was demanded. It was rejected. I was just told that besides these 14 places where a complaint can be filed, Dr. Hitesh has recently has gone and defended a doctor against whom a case has been filed in Juvenile Justice Act. Now this Juvenile Justice Act is meant कि आपने 14 साल के बच्चे को नौकर रखा हुआ है, उसको बंद करके रखते हो कमरे में, उसको चिमटे से जला देते हो, उससे काम कराते हो. It is meant for these kind of cases. And here, a child who was sucking that nipple type of thing which is put in the mouth, and the doctor had placed a tape and forgot to remove it. Or somehow the nipple came out and the tape didn't. And this was the grounds on which a case was filed in this act, where the punishment is 10 years imprisonment. So there is no end to the kind of problems we are facing, even though there are a lot of legal principles according to which one case, one series of facts should not be adjudicated in different courts or twice, more than twice. But as I say, all these principles are for citizens of India, and doctors definitely are not considered citizens of this country. Everything is in addition to Consumer Protection Act, and as I've already covered, all this is new in CPA 2019, and it has made the problems worse for us. Also, 2002 amendment of 1986 had said compensation awarded is recoverable in land revenues. So if you die and do not have not made the payments which have been awarded, your estate or your heirs will have to pay that. Also, there is substitution of legal heir in case you die during the pendency of your complaint. So this has also been included in CPA 2019, and as part of Civil Procedure Code, it is already there. At least one case is there where we had. Please understand the difference between why doctors were covered was because they said, you are taking a contract for personal service. It is not contract of personal service. Contract of personal service is, Ashwini hires me कि तूने आके मेरी मालिश करनी है, मेरे घर को पोछा लगाना है, तूने, I am his servant. He tells me तूने ये करना है, मैं वो करूँगा. You are hiring, your services are being hired. Patient comes to you and says कि जी मैंने पेट का दर्द हो रहा है. You decide what treatment is to be given, and your services is what he is hiring. He is not dictating कि you treat me this way or that way. But when you look at Samira Kohli's judgment in 2008, what did this say? Ki without the patient telling you specifically that you can go ahead and do hysterectomy, you cannot do that even though you think it is in the patient's best interest. So that means I cannot do anything which my patient master has not told me to do. So it is a master-servant relationship. If it is a master-servant relationship, why am I still covered under Consumer Protection Act? Mediation has been introduced, e-commerce has been introduced, unfair contract, this will also create problems in the times to come. Validity of consent is going to be questioned. I personally don't think CPA we will survive CPA. Medical Legal Action Group had prepared a medical injury compensation bill and sent to the Ministry of Law as well as Ministry of Health and Family Welfare. But unfortunately, nothing happened there. And I can only argue, but I cannot win because there is so much preponderance. The masala news to increase TRPs, hence the revenue of electronic media, the print media, advocates, insurers. We tried our level best. We went to Bombay High Court. We went to Supreme Court. Dr. Pradeep Arora also approached the Supreme Court. There was a case filed in Kerala High Court also. All of us lost the case for against inclusion of doctors under CPA 2019. And this was the bill we had introduced, sent to the government for consideration, which was not. Thank you. I am very, very sorry I have overstepped my time.
Thank you, Dr. Nagpal, for elaborating about CPA. But I have one question, that we all know the problems regarding criminal negligence, CPA. But what's the solution?
So solution is very, very simple. You have to tell me, what do you want? You want to punish me or you want to prevent the problem from happening again? You have to be clear in your mind, because we have a series of case reports where injection vincristine, which is to be given intravenously, was by mistake injected intrathecally. Sorry, other way around. Methotrexate was injected intrathecally when it had to be injected intravenously. And vincristine, which was to be given there, was, so this was mix-up. The question is, you can penalize the doctor by awarding 50 crores compensation, all right. But you have to read that report. Over 10 years, 55 same cases occurred in 6 continents in different hospitals. So when we are having an adversarial thing, कि ये इसने complication की, इसको punish करो, it is going to hide doctors becoming open about their complications so that others can learn how to avoid them. It pushes things under the carpet. I would much better prefer an insurance where it is like a medical accident insurance. You have accident insurance for...
Look, Dr. Nagpal, it's all right. It will happen always, complications versus negligence and other things. My question is, what our associations, all associations, have come to conclusion that this in absence of legislation. In legislation, we are made out of the purview of the CPA, but still courts are entertaining those cases. Still, we are not sleeping and not asking what should be the...
Sir, there are three ways to fight anything.
Look, I have something to say that I demanded about this capping of the compensation. We should be not more than 5 times of the consultation fees oblique total hospital bill, which when I went for the decriminalization of the medical profession, which was put to the government, and Upchara helped me a lot in bringing that issue also, that medical profession altogether should be out of the criminal purview, from the teeth of the judiciary, police and netas. That is what our aim should be. So we should ask about the capping should be how much capping. If hospital bill is 1 lakh, 5 lakhs compensation cannot be awarded by any court, whether it is civil or it is a consumer protection act. So I think we should come to a conclusion after this conference that what we want to demand from the government so that we can reach to certain.
Sir, the same demand raised.
Highlighting problem is no solution.
The same demand being raised every 3 years does not make it a new demand. What you have asked for was raised more than 20 years ago. I have written documents of that. But when you wish to fight something like this, you have 3-pronged approach. One, which is a legislative approach. Second, which is a judicial approach. And third, which is a disruptive approach. So we have failed in our judicial approach. IMA did not support medical legal action group when we went to courts on these issues. We could have collectively gone against this. We still have grounds to again go because the grounds we covered were only legislative intent. The other grounds were still left out deliberately so that larger organizations can still take up the matter to court. Sir, all together to tab hota hai na, when I am going to court and I ask people to contribute money because Supreme Court advocates don't come cheap. I get 100 messages and out of them 3 checks I got and 97 suggestions on how to raise money. That is why we don't get together.
Let us, means the organizers are hard pressed for time, but it is very important to have discussions. So the time we will always have we will be always short of time, so the discussion must continue for at least some time, otherwise it is of no use. In continuation to Dr. Rajveer's question of capping the money or the grant, I had a question about the interest. You said 9% or 18% or whatever can be given. Why at all the interest has to be given when the court doesn't give the decision for years and years? Why we should give the interest at all? We have to fight for that.
Sir, court ne jawab, this question I asked one of the Supreme Court advocates on a panel discussion with me. His answer was, the patient needed this money, this 6.5 crores in 1997. We have given the judgment in 2013. You have benefited of this 6.5 crore for these 18 years. So you should give interest. My point is, it is not my choice. And if I have taken indemnity insurance, who is benefiting by not giving the money for past 14 years? It is the indemnity insurer. Right?
So the interest, your argument should have been that the interest, if you want from me 9% or 18%, you take that interest on the amount of the bill which was paid by the patient and what I had earned from that, not the whole earning of mine for so many years or what compensation is to be given. Anyway, let's about to finish this, but you have made it interesting and lucrative and given good examples. What you have given about the gallbladder example, I would just read one line of the judgment which I received in my case of the judge from Jaipur. विपक्षी हॉस्पिटल एक 5-star हॉस्पिटल है जिसमें मरीज के इलाज के लिए भारी खर्च लिया जाता है. So judgment is based on that. They have awarded him the compensation in lakhs of rupees. So that's what I just wanted to convey with. Any other questions? Maybe 2 questions more. Sorry, Dr. Patidar, let them.
One question.
But short question, short answer.
Very short. when we explained every bit of thing in informed consent, then why can't we have that I request my doctor to operate upon me, right? Once patient requests me to operate upon me, then obligation from me is over.
No, sir. Obligation does not get over. If you operate without consent, you will definitely be prosecuted. If you operate with proper consent, you may be prosecuted.
Please, sir, in our consent, I consent to be operated, right? It should be I request to be operated.
Sir, whatever language you use, it is not going to make an iota of a difference. We have tried different languages. There is a website. Dr. Hitesh is running a website. That is the legal consent for procedures, and anybody who, because it is to be a procedure-specific consent
Yes,
now.
yes.
And the best legal consents I have found is there on their website. So I would request you people to download them, see for your own specialty and procedure, and either emulate that or use that.
Thank you, sir. We are running short of time. So we will discuss
Sir,
further. There is a
Dr.
panel
Patidar,
discussion
please,
with Nagpal, sir.
Please, sir. Please.
We have panel discussion. You can
That
ask
is totally
questions.
different from the panel about criminal part. Sir, a small question. Negligence is a person-based. Doctor is punished for his negligence, and because of that, whatsoever compensation has to be paid should be paid by that particular person. But in a new CPA, it has been covered into revenue collection. Now, is it not against the individual's fundamental right?
It is. Answer is very simple. It is. But you have to seek, you have to seize your right. You have to approach the court to get your right. It is not brought to your doorstep and delivered. And how do you approach the court to ask for your right? You have to make an effort. You have to get good professional lawyers. You have to get people like Hitesh and Pradeep Arora behind you. And then, go ahead and as a collective group. But mind you, getting a good judgment from Supreme Court is at least 2 to 3 crore game. Do not for a moment think that your brother-in-law, his Chacha ji, knows a senior advocate, Dr. Rishi Bhatia is smiling away, but this is what we do. This is what we do. Even the case lawyers I have hired, why I have hired them? Because he is the younger brother of my senior from medical college, and he gives us a discount. Of course, even that discounted money is a lot, but...
Thank you, sir. Thank you very much. Now we are closing the session, and I would like to request chairperson to facilitate sir, and Dr. Vijay Kapoor sir, Dr. Sanjay Medirata sir, Dr. Lalit Sharma to felicitate chairpersons.
हमको चेयरपर्सन को फेलिसिटेट करने में आपका टाइम जाएगा, उसमें कोई जरूरत नहीं है. We have to keep with the time, and that is how, if we are not organized in keeping time, then these problems keep coming.